This audio file is the property of LA Law Institute and is protected by copyright law. Unauthorized use, reproduction, distribution, or dissemination of this file without the express permission of LA Law Institute is strictly prohibited and may result in legal action. Any infringement of LA Law Institute's rights will be pursued to the fullest extent of the law. This audio file contains terms and definitions for the subject torts. Absolute privileges. Absolute privileges are those which give the defendant complete defense in a defamation case. They include statements made between husband and wife and those statements made during legislative, executive, or judicial proceedings. Actual malice. In a defamation suit where the plaintiff is a public figure or official, this additional element must be shown. Actual malice means that the statement was known to be false when made or there was a reckless disregard for the truthfulness of the statement. Conditional or qualified privileges. In a defamation suit, conditional privileges are those which are given for a good faith use, such as permission to use name or to protect the public or a common interest. If abused, the privilege may be lost. Consent. Consent must be voluntary, informed, and with legal capacity, and may be implied or express. A complete defense. Constitutional privileges. Covers public figures, public officials, or public concern in a defamation case. Defamation. Under common law, a false defamatory statement, of and concerning the plaintiff, published to a third party which causes damages. Under the First Amendment, there are two additional requirements when the plaintiff is a public figure or the matter is of public concern that must be proved. They are falsity of the statement and fault on the part of the defendant. Libel. Libel is written defamation. Considered to be more damaging than slander due to its written format, which may be disseminated. Libel per quad. When written defamation is not obvious and must be proved. Requires inducement and innuendo, which are extrinsic factors that help to prove the writing is defamatory. Libel per se. Libel is written defamation. A writing that is clearly defamatory is libel per se and does not require proof of special damages to also get general damages. In libel law, special damages are economic and tend to be for loss of customers, income, or a business. NY Times v. Sullivan. A landmark defamation case that ruled a public official or public figure cannot recover unless they can prove actual malice. Slander. Slander is spoken defamation. It requires proof of special or monetary damages to get general damages. Slander per se. Slander per se refers to slander that is clearly defamatory on its face, and special damages are therefore presumed. 4 types of slander which will prove slander per se: criminal behavior, a loathsome disease, unchastity, illegal business practices. This acronym can be remembered with the word club. Truth. When the statement is accurate, there is no defamation. Truth is a complete defense. Inducing breach of contract. A volitional act done with the requisite intent which causes a third person to breach an existing contract with the plaintiff. Interference with prospective advantage. A volitional act done with the requisite intent which causes a third person to refrain from entering into a contract with the plaintiff. Misrepresentation. An affirmative misrepresentation of a material fact by the defendant with the requisite intent and with scienter which causes the plaintiff to suffer damages. Negligent misrepresentation. Primarily affecting business dealings, where a duty of care is not exercised regarding a material fact which causes the plaintiff to justifiably rely, which then causes damages. Intent. Intent is the mental state that the defendant has at the time of the voluntary act. It can be inferred by the knowledge the harm will occur or that it is substantially certain to occur. Transferred intent. When an intended action towards one person is transferred to a second victim and a second tort is committed. Re-entry upon land. A person may re-enter someone else's land in order to regain possession. Reasonable force may be used after demand to tortfeasor to vacate. Assault. Volitional act done with requisite intent which causes the plaintiff to suffer reasonable apprehension of an immediate battery. The plaintiff must be aware of the assault or at least be caused harm. Authority. Using legal authority, one may arrest another that he reasonably believes has committed a crime. Battery. Volitional act done with requisite intent which causes the plaintiff to suffer a harmful or offensive contact or touching. Consent. Express or implied. Must be voluntary, informed and with legal capacity. A complete defense. Conversion. Volitional act done with requisite intent which causes the destruction of or serious and substantial interference with the plaintiff's chattel. Defense of others. The reasonable use of force to defend another against imminent and unprivileged attack. A reasonable mistake is permitted. Defense of property. The reasonable use of non-deadly force to regain property is permitted. Discipline. A party who is responsible for a child may use reasonable force to discipline. False imprisonment. Volitional act done with requisite intent which causes the plaintiff to be confined to a bounded area. Does not have to be aware of confinement but must be damaged. Intentional infliction of emotional distress. Volitional act done with requisite intent which amounts to extreme and outrageous conduct and which causes the plaintiff to suffer severe emotional distress. If defendant is shopkeeper or common carrier, there is a higher standard of care expected. 3 protected classes, pregnant women, elderly and children, are considered more susceptible and conduct of offender will be judged more harshly. See bystander rule. Private necessity. The privilege to harm property of another to avoid personal harm to self or other property. However, still remains liable for damages. Private nuisance. Volitional act done with requisite intent which causes a substantial and unreasonable interference with the plaintiff's use and enjoyment of his land. Privileges and defenses to intentional torts. Discipline, authority, recapture of chattel, necessity, consent, defense of others, defense of property and self-defense. The memory device for this list is darn cops. Public necessity. Privilege to harm property of another to avoid harm to public. Protect the greater good. Not liable for damages. Public nuisance. Volitional act done with the requisite intent which unreasonably interferes with the health, safety, or property rights of the community at large. Recapture of chattel. While in hot pursuit, one may use reasonable force to recapture a wrongfully taken chattel. No mistakes are permitted. This is a complete defense. Self-defense. The reasonable use of force to defend against imminent and unprivileged attack. Deadly force may be used if in danger of death or serious bodily injury. Shopkeeper rule. Detention for investigation of someone suspected of shoplifting, theft of similar situation. Must be done in reasonable time, with reasonable grounds using reasonable force. Used with the defense of recovery of property. Trespass to chattels. Volitional act done with the requisite intent which causes an interference with the plaintiff's chattel. Trespass to land. Volitional act done with requisite intent which causes a physical invasion of the plaintiff's land. Appropriation of likeness. Appropriation of likeness occurs when one uses the likeness or voice of someone else for financial gain without permission. False light. False light is the publication of untruthful claims against a person which may be cause for a defamation case. Intrusion upon seclusion. An intentional intrusion into the private affairs of another or into an area of expected privacy. Invasion of privacy. Invasion of privacy is a set of 4 separate torts. Intrusion upon seclusion, false light, appropriation of likeness and public disclosure of private facts. Abuse of process. Using a civil complaint for improper purposes. Concurrent tortfeasors. 2 or more tortfeasors not working together that create a single injury to plaintiff. Contribution. When there are multiple tortfeasors, each is liable for their respective amount. If one pays entire amount or more than his share, he may then sue for reimbursement from the other liable tortfeasors. Indemnity. When one party is guilty and a second party is financially responsible, the second party may sue for reimbursement from the first party. Joint and several liability. Where there are 2 or more tortfeasors who are liable for an injury, both will be jointly and separately liable for the entire damage amount. However, more than 100% cannot be collected from either/any of the parties in total. Joint tortfeasors. At least 2 tortfeasors that participate in a criminal act to cause an injury to plaintiff. Malicious prosecution. Bringing an action against a defendant without probable cause which damages defendant's reputation or causes emotional suffering. Reasonably prudent person test. Standard test in torts to compare actions between defendant and those of the hypothetical reasonably prudent person under the same or similar circumstances to determine if there is liability. Respondeat superior. The superior is liable for the acts of their agent that are within the scope and course of their employment. No liability for independent contractors unless involved in inherently dangerous activities or non-delegable duties. Statute of limitation. In most jurisdictions, the statute of limitations is 2 years from the time of the injury. Successive tortfeasors. When there are 2 or more tortfeasors causing successive impacts which cause a single harm to plaintiff. Vicarious liability. Being held liable for the actions of another based on relationship or circumstance. Wrongful death. A modern law statute that family members/dependents may sue for loss of future earnings from the decedent. Actual cause. The factual cause of the plaintiff's harm. If not for the defendant's action, the harm would not have occurred. Satisfies the but for test. But for the defendant's action, the harm would not have occurred. Assumption of the risk. A defense where the plaintiff was aware of the potential harm and willingly accepted the danger. A complete bar to recovery. Attractive nuisance. A child trespasser that is lured onto the land by or discovers a dangerous situation. Landowner has a duty to warn or make safe. Plaintiff must take action to mitigate damages. Not a duty. Excess losses may not be compensated. Breach of duty. The failure to act as a reasonably prudent person in the same or similar circumstances. This failure is the cause of the breach of the duty owed to plaintiff. But for. A test that asks but for the defendant's act, would the harm occurred? A way to determine liability. Causation. Actual and proximate cause of the plaintiff's injuries. Must occur at the same time. Collateral source rule. If plaintiff receives money from outside sources, defendant may not claim that money towards repayment of damages. Comparative negligence. Comparative negligence measures the plaintiff's own responsibility for harm. In a pure comparative state, such as California, plaintiff will always recover some amount equal to defendant's percentage of harm, even if 99%. In a partial jurisdictions, if the plaintiff is liable for 50% or more of their own harm, there is no recovery. Contributory negligence. A common law defense that holds that if the plaintiff was at least partially responsible for their own resulting harm, it is a complete bar to recovery. Last clear chance doctrine was enacted to counter the severity of this claim. Defenses to negligence. Contributory negligence, comparative negligence, partial and pure, assumption of the risk. Duty. Generally everyone owes a duty to not subject others to unreasonable risk of harm which can be measured by the reasonably prudent person acting under the same or similar situation. The rule of duty consists of 2 parts. To whom was the duty owed and what kind of duty was owed? General damages. Money award for pain, suffering and inconvenience. Does not require proof like special damages. General rule of duty. The general rule of duty is there is no duty unless there is an affirmative act or a special relationship. Everyone owes a duty to not subject others to unreasonable risk of harm which can be measured by the reasonably prudent person acting under the same or similar situation. Intervening acts. When something comes between the harmful act and the injury which severs liability. It cuts off liability when the resulting harm becomes unforeseeable. Acts of God, animals or a third party are foreseeable, superseding intervening acts and do not cut off liability. Invitee. May be either public or business invitee. A person that enters someplace for which the land is maintained. Known trespasser. If a trespasser is known about by landowner, a duty exists to warn of hazardous, artificial, conditions. Learned hand/balancing test. A way to measure the risk versus utility of a defendant's actions. Weighing the burden against the possibility of injury, the extent of injury, against the likelihood of injury. Licensee. Social guests or those who enter with permission. Duty to warn of hazardous, artificial, conditions or make safe. Negligence. When the defendant owes a duty of care to the plaintiff and the breach of that duty was the actual and proximate causes of plaintiff's damages. Negligence per se. When the defendant owes a duty of care to the plaintiff and the breach of that duty is the violation of a statute. The statute was designed to protect against the type of harm suffered and was meant to protect a plaintiff from that kind of harm. Violation of the statute suffices for both duty and breach in prima facie case. Negligent infliction of emotional distress. Duty to not subject others to a foreseeable risk of harm that might result in emotional distress. Most jurisdictions require victim to be within zone of danger to recover for emotional distress. If no physical harm, plaintiff must 1. Prove emotional distress and either A. Be in zone or danger or B. Be present and aware of injury to relative. Omission to act. Under the rule of duty, one must act under certain conditions. Scrap LC. Statute. Contractual. Relationship. Accepting the duty. Placing victim in peril. Landowner/occupier. Common carrier/shopkeeper. See special duty. Palsgraf. In Palsgraf v. Long Island Railroad, Justice Cardozo wrote the majority view that a defendant only owes a duty to care to those that are foreseeable which are in the zone of danger. Justice Andrews wrote the minority view which states that defendant owes a duty of care to everyone. Proximate cause. Used to establish the scope of liability. Injury must be foreseeable. A superseding intervening act such as by an animal, act of God or third party will not cut off liability. Exceptions are made for rescuers or thin-skulled plaintiff. Res ipsa loquitur. The thing speaks for itself. Res ipsa loquitur is a rule of evidence that allows the plaintiff to show elements which help prove a breach of duty. Elements: the thing that caused harm was in control of D at the time of injury. Accidents of this nature do not normally happen without negligence. The plaintiff did not contribute to their own injury and D is in a better position to explain what happened. Special damages. Monetary award for loss of income, medical bills or economic losses which must be proved to collect. Special duty. There are certain situations which require the defendant to observe a higher standard of care. The acronym SCRAP LC lists these relationships which are: statute, contractual, relationship, assumption of care, peril, causing it or placing the plaintiff in the peril, landowner/occupier, common carrier/shopkeeper. See omission to act. Strict liability and negligence. An absolute duty to make safe and not subject others to an unreasonable risk of harm. Substantial factor. When more than one person is responsible for the harm, each may be liable if the act was a substantial factor, not trivial or remote, in bringing about the harm. Thin-skulled plaintiff. A defendant who already has physical deficiencies which make injury more severe than someone without deficiencies. The defendant takes the plaintiff as they find them. Trespasser. Trespassers may be either undiscovered or known. If undiscovered, no duty. If known or should have known, must warn of hidden, artificial dangers. Design defect. A product that has an inherently dangerous design. Express warranties. A promise that a product will work or will work in a certain way. May be based on a sample, a brochure, slogan or other advertisements. Implied warranties. Every product comes with an implied warranty of merchantability and fitness for a particular use. Merchantability means that the product matches the standards of like kind and quality of similar products. Implied warranty of fitness for a particular use means that the customer informed the salesperson of requirements and relied on the seller's expertise that the product was sufficient to meet those needs. Manufacturing defect. A manufacturing defect occurs when the product does not conform to design specifications and is different from other like-produced products. Negligence, product liability. Failure of any party in the chain of commerce to inspect, discover and correct defects. Written as a standard negligence claim using duty, breach, causation, and damages. Product liability. Any entity such as a manufacturer, distributor, wholesaler or retailer that releases an unreasonably dangerous product into the stream of commerce may be liable for personal injury, property damage and other harm caused. Liability may be based on the following theories: warranty, negligence or strict liability and tort. Product liability types of breach: manufacturing, warning or design defects. Strict liability and tort. If a defective product is placed in the stream of commerce, the manufacturer is strictly liable for any injury to person or property. Warning defect. The product is made as intended but fails to warn or instruct users as to potential risks or dangers. Warranty. With the sale of every product there are two theories of warranty, implied warranty and express warranty. The warranty is the promise that the product will work in a certain way. Strict liability. Liability without fault. There are three kinds of strict liability. Strict product liability and tort, strict liability and negligence, and strict liability for abnormally dangerous activities and exotic animals. Strict liability for abnormally dangerous activities and exotic animals is a standalone tort. Strict liability, the tort. Strict liability is liability without fault. The defendant has an absolute duty to make safe. Categories include animals and ultra-hazardous or abnormally dangerous activities. Animals must be exotic or domestic with a violent propensity. Activities should be of value to the community, are commonly done in the area or at least appropriate to the area. Colloquium. When a defamatory statement is not clear as to whom the statement is concerning, a colloquium may be pleaded by the plaintiff to use extrinsic facts for proof that they were the intended recipient of the defamation. Crime prevention. Using reasonable force to prevent a crime. Loss of consortium. When a family member has been injured or killed, a claim may be brought for the loss of services, companionship, affection, financial support or, in husband/wife cases, loss of sexual relations. Inducement. Extrinsic facts which are used to help clarify a defamatory statement. Used with innuendo. Innuendo. Tying extrinsic facts from an inducement to the defamation to clarify the remarks. See inducement. Survival statutes. Under modern law, a lawsuit may continue by the estate of the decedent. Intentional infliction of emotional distress, bystander rule. In an IIED case where the injured is a bystander, three elements must be shown. 1. Bystander was a relative of injured. 2. Bystander was present at time of injury. 3. Defendant knew bystander was a relative and was present at time of injury, combination of element 1 and 2. Superseding cause. A superseding intervening act is an event that serves to cut off liability. Defamatory statement. A statement that negatively affects one's reputation. Must be shown to be a fact versus opinion. Only the living can be defamed. Requisite intent. Requisite intent is the type of intent that is required by each specific tort. Types of intent include specific intent, general intent, and strict liability.